I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. One of the biggest myths in employment law is that documentation is only important if you're planning to terminate someone, right? So as soon as we decide we're going to let somebody go, we get out those pads of paper, we take those notes, we dictate the summary, and we think, okay, we're ready to roll because we're terminating somebody. But nothing could be further from the truth. Documentation is important all the time about everything you do. And today, I want to talk about why good employers lose lawsuits. Not because they made the wrong decision, but because they couldn't prove they made the right one. Okay, I really want you to hear me on this. I know we think that when somebody files a lawsuit, they have the burden of proof. But in many employment law cases, the employer has to prove they did the right thing. It's really our burden as employers. So I want you to think about documentation and why it matters. Here's the thing, you guys. Documentation tells a story. It explains what happened, when it happened, who said what, why a decision was made. And judges and juries and arbitrators love contemporaneous documentation. Documentation that happens in the moment, at the time something is happening. Not when I call a client and say, hey, you've been sued. I want you to go back and write down everything you remember that happened with this individual. I mean, that's important for me to know how to defend the case, but it's not going to be real persuasive to a jury or a judge or an arbitrator because it was prepared after I told them to do it. It's not contemporaneous. The employer had a motivation to craft that documentation in a way that made them look the best, okay? The other problem with not having contemporaneous documentation is that memories fail, right? I don't even remember what I had for lunch yesterday. So I'm not going to remember some conversation I had 6 months ago. Memories are inherently unreliable. Even when they're contemporaneous, sometimes we remember something that didn't happen, right? Or we describe somebody in a way that is inaccurate because we have a bias or stereotype in our mind. But when you document contemporaneously, when you do it at the time something is happening, that feels more objective. It's less conclusory, right? I'm actually just writing down what happened. And I'm not using labels. I'm not saying Jen is lazy. Jen isn't a good team player. Jen doesn't have a good attitude. I'm documenting specific examples, specific things that have happened. That's what we're going to be looking at, all right? And when you have documentation that actually does that, your performance coaching, your performance reviews and evaluations are much more effective. I do evaluations at our firm at the end of every year. And I usually use the week of Thanksgiving to kind of get organized, make sure I've got everything and start drafting. And what happens is when I am trying to remember all of the things that have happened in the last year, if I don't have notes, I pick the things that stood out to me the most, right? The most egregious thing and the best thing, and I miss everything in between. So luckily, 20 years ago when we started this firm, I realized, okay, I got to document things. And so I have a file on, everything that happens that I think could be relevant down the road at a performance review time. So it makes it easier for me to draft those evaluations, whether we're talking about a performance issue or something that somebody did really well. I don't want to forget to mention all of the good things that somebody did. Documentation is important to every aspect of employment law. Whether we're talking about hiring somebody, conversations you've had with leaders about what type of position you're going to be creating, eliminating a position for business reasons, closing a location, making sure that you have informed employees of their rights to take time off, their rights to reasonable accommodation, that you have created appropriate documentation for their job duties so everybody knows what needs to be done. All of this is documentation, okay? It's things we have written down about the workplace. And when we don't do this correctly, when we wait weeks and months to do it, when we include emotional language rather than something more objective, when we are vague, Jennifer has an attendance problem, instead of over the last 30 days, Jennifer has been late to the office 17 times, 14 of which were greater than 30 minutes. Right? Okay. Now we've got some data, right? Much more helpful than this sort of vague, generic statement. When you document something and you don't follow up, right? You got a problem. So you create documentation that says this might be happening, and I'm going to talk to Matilda about this next week. And then next week comes and you get busy and you forget to do it. Well, that documentation still exists, right? But now it's not going to be helpful to you because it shows you didn't do what you were supposed to do. So documentation can actually help you or hang you, right? It just depends on what the documentation is. Years ago, I was defending an age discrimination case, and I asked the client for the personnel file of a number of employees. And the person who was suing was actually an applicant who had not been hired. And I said, okay, give me all the resumes. What did you collect as part of this process? And the client said, oh, I've also got some notes from interviews. Okay, great. Send me everything you have. I'm starting to go through the documents, and I come to the application of this person who was suing the company. And at the top of the application, in big, bold Sharpie ink, it said too old. Now, when I asked the client about it, they had a very good explanation. They felt that this was a very physical position. There were some safety issues involved. They didn't think this woman, who they perceived as older, I think she was about 60, that she was ready to take on that kind of a role. But they commented at the top, too old. Okay, this is an age discrimination case. You know what I'm going to tell you next, right? They settled. They had to. Because if I had to disclose that document, we were going to have a problem. And honestly, I don't think there was age discrimination. They really didn't believe this person was qualified for the job, but they didn't document it appropriately. So that's what I was talking about at the beginning of the podcast when I said, there's this myth that the only time documentation matters is when you're about to fire somebody, but that's just not the case. Good documentation is important with respect to every decision you make at work, whether it's pre-employment, during employment, after somebody leaves and you give a reference, right? You better document that. So good documentation backs up good decisions, right? But if you don't have the documentation, if you haven't taught people in your organization what constitutes effective documentation, that it's in writing, that it's dated, that we know who wrote it, that it tells both sides of a story, both sides of the conversation, all of those factors are critical to having effective documentation. And when you do that, when you've got a culture of creating good, effective documentation, then you can back up your decisions. People may still disagree with the decisions, but you can point to the memo you wrote, or the newsletter item you included, or the personal note that you took after an interview or during an interview. That type of documentation gets you out of lawsuits, gets cases dismissed, convinces judges and juries and arbitrators that you're telling the truth. Without that documentation, if you have a good lawyer on the other side who can really spin a story, you're going to be in trouble. And we have a nonprofit client that just went through this recently. They fired their executive director. They had a very good reason to do it. Horrible performance issues, bad attitude, lots of problems. But they didn't have documentation. And the executive director had a very effective lawyer who told a very effective story before the jury. And they sided with the executive director. They sided with the employee. And it's, in my opinion, a grave miscarriage of justice, because there really is nothing that this organization did wrong. But this employee was able to take really significant advantage of the fact that there was not sufficient documentation of his performance issues. And that was such a good reminder to me of how important this documentation is. It doesn't have to be fancy. It doesn't have to be in an HRIS system. It can be in a notebook, a steno pad that you use. I don't care. But you've got to be able to show that you gave feedback, or you made the decision for a legitimate reason, or you denied the leave because they didn't return the form, whatever it is. If it's not written down, folks, it didn't happen. And it's interesting because documentation is really something that we do a lot of course, in the workplace without thinking about the fact that it's documentation, like policies and procedures, right? That's documentation. We're writing down what we want our employees to be doing. But you've got to have the documentation available. It has to be consistent. You need to hold people accountable. You can't have one supervisor who documents everything and another who doesn't. That's going to be a problem as well. So we have to drive, from an HR perspective, we have to drive compliance with this expectation, right? You need to be writing things down, and we can make it easy, right? We can give them forms to fill out. It can be in longhand. I don't care, as I said. We just need the documentation, and we need to be able to show that it was contemporaneous with the decisions that are being made. Now, speaking of policies and procedures, this week, I want to highlight another service of Employers Lawyer, which is called our Policies and Procedures Hub. California employers do not have to reinvent the wheel every time they need a new policy or procedure. At least they shouldn't have to do that. Obviously, you can go on the internet and find anything you want, but you don't know if it's good. You don't know if it's written appropriately. You don't know if it complies with California law. The Employers Lawyer Policies and Procedures Hub is filling up very quickly with policies, forms, templates, checklists, and practical guidance that Joe and I developed specifically for California employers. Remember, when we talk about Ella, our AI legal assistant, or our policies and procedures, everything we do at Employers Lawyer is based on the work that Joe and I have done for the last 30 plus years. So whether you're updating your employee handbook, you're implementing a new legal requirement, you're responding to a workplace complaint, the Hub gives you practical resources you can put to work immediately to build a stronger, more consistent workplace culture, okay? Remember that at Employers Lawyer, we have 3 client levels: the core, which is $100 a month, all the way up to the fanciest, most high-touch service level, which is the signature level, and that is $600 a month. And it's all inclusive, folks. Joe and I are doing this because we want to give back to the HR community. We don't think any employer should be without access to good legal advice when it comes to the workplace. And that's what Employers Lawyer is all about. So check us out at employerslawyer.com. Also, I want to give you something to focus on for the week, a practical action step. I want you to find one disciplinary memo that has been delivered to one of your employees. A corrective action, performance improvement plan, letter of instruction, whatever you call it. And I want you to ask yourself after you read that document, would someone who wasn't there understand exactly what happened? And if the answer is no, you've got work to do, right? You've got training that needs to be done. Because documentation, folks, is not just about creating a paper trail. It's about creating clarity. That's why it's so important. Everyone, we've come to the end of our time today. Thank you so much for joining me. It's always such an honor and a privilege. I hope you have a wonderful rest of your week. Go out and do something nice for someone, and I'll see you next Wednesday. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.